Good day, my name is Joinder. I teach Law of Criminal Procedure at the University of the Western Cape, and this specific video deals with charge sheets and indictments in our criminal courts. What's important initially about this specific section of our law and in terms of criminal procedure is that the accused person always has a right to information in terms of the charges that are brought against him. In this case, it's regulated by Section 32 of the Constitution, as well as sections in Section 35 that protects the right to information of the accused person. So it's very important that the accused person is aware of the charges that are brought against him. The accused person can ask, but I was at my mother's house on Sunday. Why is the police saying and state alleging that I have committed a specific crime on that day? What is the information that they have on me? Why was I arrested? Why am I not going on trial for a specific offense that they are alleging that I have committed? So the accused must be made aware of the charges that are brought against him, and these charges will be included in a document or documents depending on the court. So even before one should look at the documents that will be served on the accused person or where the charges will be included in, one should first look at the document that is called the police docket. So the police docket is always the property of the South African Police Service, SAPS, and it will be in the possession at large stages of the process. It will be in the possession of the prosecution, the National Prosecuting Authority, and the prosecuting authority will use this as evidence against the accused. And it can be quite a large document if you can think of all the evidence that can be included against an accused person, all the necessary documentation and documentary evidence that can be included in such a docket. It's important that the state is always aware of the presence of this docket, where it is. And of course, there's always many stories about police dockets going missing. I have been asking police officers and prosecutors about this. They say it doesn't happen often, but if it does, it's a big problem for the state, and they have to build their case over again if a police docket goes missing, which is very difficult maybe if a witness has since passed away or something has happened to a witness, or the accused person can also, for example, have done something to the crime scene, went there after the police done the investigation and removed something that the police didn't see initially, or anything can happen in that case. So it's important for the police to always ensure that the document and the police docket is safe. So the police docket consists of 3 sections. So it's Section A, Section B, and as well as Section C. So Section A contains, for example, documentary evidence, statement from witnesses, expert reports, whereas you can think that's, of course, very important for the defense to be aware of that information. And we'll get to that now. Then Section B would usually include internal reports and memoranda, and then the Section C is very private to the state and the prosecution. It will usually include the investigation diary. So it's all the notes that the state and the police make that to think about how they can improve or strengthen their case. So generally, it was decided in the National Director of Public Prosecutions versus King case in 1996 at the Supreme Court of Appeal that the accused person has a right to further particulars of the police docket, is able to view the information in the police docket, but mainly only Section A. So there have been cases where the courts have allowed the accused person to also look at Sections B and C. In a very popular case or infamous case in the Eastern Cape, it was the accused person, Panayotu, who unfortunately was convicted of murdering his wife by hiring 2 hitmen who who abducted her and murdered her, he was able to get access to the C part, and his defense team was able to show the court that it was important for them to look at that specific part, which the court then agreed to. So this is depending on a case-by-case basis whether the court will allow such disclosure. Then there was also another case in the past. It was Du Toit versus Magistrate, 2016 Supreme Court of Appeal case, where the court also decided that it was a very sensitive matter regarding child pornography. And of course, then the state was in possession of the child pornography files and videos. And in this case, the court actually decided that the defense team can come to a police station and view the material there because of its sensitive nature. So as you can see, each case depends on the facts of a case and the sensitivity as to whether the court will grant certain access, especially to section B and C of the police docket. Because it's very sensitive information and very personal information that are included usually in these sections. And then it also depends on the sensitivity of the crime as well, whether the defense will have access. But as a general rule, the defense team will usually have access to section A of the police docket. So that's a very important part of access to information for the accused person. Now heading back to court. So once your bail proceeding is done, the accused person will await his trial, and then the charge sheet will be drawn, or the indictment. So charge sheets you will only find in magistrate courts. So in a magistrate court, there's a district court section, as well as a regional court section. So there are two sections, mainly because there are various types of crimes that are less serious and more serious. So your more serious crimes will usually go to the regional court, and your less serious crimes will go to the lower courts. For example, theft, which is a less serious crime, will go to the regional, or go to the lower court, the district court, and then your murder, not aggravated, so just an accused person, for example, stabbing an accused at the spur of the moment and running away. The accused didn't plan the murder, so it's not premeditated murder. It's not a planned murder. Those usually go to the high court, but some are also heard at the regional court. So that's just to also mention that difference between regional courts and district courts within the magistrate court system. So in both those courts, charge sheets will be drawn and will be written up and will be completed by the state, and it's very important for that document then to be produced in court. Such a document, the charge sheet, is not served on an accused person in a magistrate court, but it is the summons that is served on the accused person at least 14 days before the trial. And then a written notice of appear can also be used in magistrate court cases. And then it is important for certain information to be included in a charge sheet or indictment. Okay, but let's have a look also at the high courts. So in a high court, you will not speak about a charge sheet. You will speak about an indictment. So an indictment is a document that includes the charges against the accused person, and this document will then be served on the accused person at least 10 days before the trial. So in a specific charge sheet or indictment, the general or substantive requirements for these documents are usually that the name of the accused person must be included in the document. So it's really important. So the particulars of the accused person. Then it's also important for the state to include the offense that have been committed, but then also where was it committed and on which day. So you'll often see the words that are used in that, on, or about on that day, at or near that specific location. It is then alleged that the accused person committed a crime. So there's various particulars that the state will have to include in a charge sheet or an indictment. So a charge sheet would usually consist is also called a J15, a J15, and it will also include a preamble, and it won't be a very long document, very large document. However, in your high courts, you have sometimes an indictment that is 700 pages long. And it, of course, depends if it's a money laundering case or anti-economic crime case. These cases can include thousands of charges. And then your document will be very long. But usually, for murder cases, it's about 70 to 80 pages long. And it also depends on the amount of witnesses that the state will have to call. Because unlike a charge sheet, which will include the basic details of the crime that was allegedly committed, where and when, and against whom, that's also a very important aspect of a charge sheet or indictment. It must also include against whom the crime was committed. On top of that, an indictment also has various sections to it, and some of these sections are called the various particulars of the indictment, which includes a summary of the facts, so that you won't see in a charge sheet. And then also you need to include, as a state, a list of witnesses at the end of an indictment. So it's really important that that information is included in an indictment. So that is insofar it goes in terms of charge sheets and indictments at magistrate courts and higher courts. Initially, the charge sheet will be lodged with the clerk of the lower court, whereas the indictment will be lodged with the registrar of the high court. So that is basically charge sheets and indictments in criminal matters. What should also be understood is the types of charges that can be included in a charge sheet or indictment. There's a general rule regarding splitting of charges and duplication of convictions. I want to mention that again. Splitting of charges and duplication of convictions. So splitting of charges means, for example, where an accused person, I'm going to use a very popular case called State versus Nambela, where an accused person was allegedly using drugs, and the police officer saw him and then he ran away. So a police officer will usually tell you in that case to stop, and if you don't stop, that's already also an offense of not obeying of a police order. So he's running away, and then he reaches a fence where he, in the event of running away and the police officer actually getting to him and grabbing his clothes, he then kicks the police officer in the face and is able to escape, but then later arrested. Now, at the trial, and even during the charge sheet, the state must now decide what offenses will be included in the charge sheet. So they include the offense of not obeying the police officer's instruction, but they also include assault, because according to him, the accused person kicked the police officer in the face, which makes sense. So those offenses are included. And then, of course, possession of drugs. So those offenses are included, but then the court decides, so that is called splitting of charges. So you have one event, but there's splitting of charges. This is done to show the community that the conduct of the accused is wrong. It's against the community mores. So it's important for the state to charge and then convict crime, to show the community that it's wrong, of course. I mean, it's important as part of the theories of punishment as well, in terms of retribution and deterrence. But then also it's important for punishment. So if an accused person is convicted of more than one offense, the sentencing will also increase, of course. So, but there's a danger to it, and this is a general rule in our courts. So if there's a prosecutor can include as many charges as they wish. Okay, there's not necessarily a provision in the CPA that says you cannot include 1,000 charges. There isn't something like that. But the courts are very careful when it comes to duplication of convictions. So now, turning back to Nambela, The question is, should Nambela be convicted of all these offenses? Should he be convicted of not obeying the police officer's instruction? Should he be convicted of assault? And should he be convicted of possession of drugs? In that case, the court convicted him of possession of drugs, as well as not obeying the instruction of the police officer. They did not convict him of assault, because it was held by the court that in the event of running away from the police officer, it was in the same crime that was allegedly taking place, of him not obeying the instruction of the police officer, that he used aggravation to get further away from the police officer or to escape police custody. So it's still the same crime. The court held that we cannot convict the accused of an additional crime because it's still part of the first crime. If we convict him of an additional crime, which is assault, we will duplicate a conviction, and that is not allowed. But that's just a difference between splitting of charges, which is usually okay, and the splitting will be quite normal in a charge sheet, because when a charge sheet is drafted, the state's not always sure whether they will get a conviction on all those charges. There might be alternative charges as well. An alternative charge, for example, to murder is culpable homicide. So in these cases, it's always tricky for the state to exactly know what the court will convict the accused person on. So the courts are very careful when it comes to duplication of convictions. So it's important also for one to understand the difference between a charge and a conviction. A charge is simply the state saying that we alleged you have committed the crime of murder, whereas a conviction is when the court states that you are guilty of the crime of murder. And then, of course, sentencing will take place afterwards, where the court will state that we find you, after finding you guilty of the crime of murder, it's now our duty to sentence you to imprisonment of 20 years or life imprisonment for the specific crime, in accordance with the Criminal Procedure Act and in accordance with the Criminal Law Amendment Act 105 of 1997. So it's important for us to understand how the court looks at charges. So it's very important. There can also be a joinder of various offenses in these charge sheets, but then they can also, or indictments, and then there can also be an occasion where trials can be joined in terms of various offenders. So sometimes you will see a charge sheet or indictment where there's more than one accused person. And this is very important when the accused persons form part of a gang, or when there's accessories, or when there's accomplices, and they all contributed to the same crime on the same facts. So then it's important for the state to form this case against all these accused persons. And it's also very interesting to sometimes see the accused persons then also saying that the other accused person is lying during evidence or during the trial, which sometimes is in favor of the state, not the defense. So, but it depends on a case-by-case basis. So that is just a very brief overview of charge sheets and indictments. And again, just if you want to take anything from this specific presentation or specific session or presentation, it's really important to just remember that every accused person has that right to information, and the state has a duty to provide that information to the accused person. Otherwise, that's a severe violation of the constitutional rights of the accused person. Thank you so much for listening, and I hope this helps you to better understand charge sheets and indictments. Thank you.